Hi, my name is Janna from Oloy 22 and 8. My subject is criminal evidence. Define object evidence. Object as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to examine or view by the court. Define documentary evidence. Documents as evidence consist of writings or any material containing letters, words, numbers, figures, symbols, or other modes of written expression offered as proof of their contents. What is best evident rule in original evidence rule? The original of the document is one of the contents of which are the subject of inquiry. When a document is in two or more copies executed at or about the same time with identical contents, all such copies are equally regarded as originals. What is secondary evidence? When the original document has been lost or destroyed or cannot be produced in court, the affair upon proof of its execution or existence and the cause of its unavailability without bad faith on his part may prove its content by a copy or by a recital of its contents in some authentic document or by the testimony of witnesses in the order stated. What is testimonial evidence? Testimonial evidence consists of the statement or declaration of a witness offered to the court. It may be oral, live, or by judicial affidavit. What is parole evidence rule? When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be between the parties and their successors in interest no evidence of such terms other than the contents of the written agreement. What are the qualification of witness? As general rule, all person who can perceive and perceiving can make their known perception to others may be witnesses. Religious or political beliefs, interest in the outcome of the case or conviction of a crime unless otherwise provided by law shall not be ground for disqualification. What are the grounds for disqualification of witness? Grounds for disqualification of witness is disqualification by reason of mental incapacity or immaturity, disqualification by reason of marriage, disqualification by reason of death or insanity of adverse party, disqualification by reason of privileged communication. What is the hearsay evidence rule? The hearsay evidence rule bars the testimony of a witness who merely recites what someone else has told him, whether orally or in writing. Any evidence, whether oral or documentary, is hearsay if its probative value is not based on personal knowledge of the witness, but on the witness, but on the knowledge of some other person, not on the witness stand. What are the 11 exemptions to the hearsay evidence rule? Dying declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry, as evidence of the cause and surrounding circumstances of such deaths. Declaration against interest. The declaration against interest by a person deceased or unable to testify against the interest of the declarants if the fact is asserted in the declaration was at the time it was made so far contrary to declarant's own interest that a reasonable man in his position would not have made the declaration unless he believed it to be true, may be received in evidence against himself or his successors in interest and against third persons. Act or declaration about pedigree. The act or declaration of a person deceased or unable to testify in respect to the pedigree of another person related to him by birth or marriage may be received in evidence where it occurred before the controversy, and the relationship between the two persons is shown by evidence other than such act or declaration. The word pedigree includes relationship, family genealogy, birth, marriage, death, the dates when, and the places where this past occurred, and the names of the relatives. It embraces also facts of family history intimately connected with pedigree. Uh, with pedigree. Family reputation or tradition regarding pedigree. The reputation or tradition existing in a family previous to the controversy in respect to the pedigree of any one of its members may be received in evidence if the witness testifying thereon be also a member of the family, either by consanguinity or affinity. Entries in family Bibles or other family books or charts, engravings on rings, and family or portraits, and the like may be received as evidence of pedigree. Common reputation. Common reputation existing previous to the controversy, respecting facts or public or general interest more than 30 years old, or respecting marriage or moral character, may be given in evidence. Monuments and inscriptions in public places may be received as evidence of common reputation. Parts of register. Statements made by a person while a startling occurrence is taking place or immediately prior, or the subsequent thereto with respect to the circumstances thereof, may be given in evidence as part of res gestae. So also, statement accompanying an equivocal act material to the issue and giving it a legal significance may be received as part of the res gestae. Crimes in the course of business. Entries made at or near the time of transaction to which they refer by a person deceased or unable to testify, who was in a position to know the facts therein stated, may be received as prima facie evidence. If such person made the entries in his professional capacity or in the performance of duty and in the ordinary or regular course of business or duty. Entries in official records. Entries on official records made in the performance of his duty by a public officer of the Philippines or by a person in the performance of a duty specially enjoined by law are prima facie evidence of the facts therein stated. Um, Commercial lease and the like. Evidence of statement of materials of interest to person engaged or in an occupation contained in a lease, register, periodical, or other published compilation is admissible as tending to prove the truth of any relevant matter so stated if that compilation is published for use by person engaged in that occupation and is generally used and relied upon by them therein. Learned treatise. A published treatise, periodical, or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice or a witness expert in the subject testifies that the writer of the statement in the treatise, periodical, or pamphlet is recognized in his profession, profession or calling as expert in the subject. testimony or deposition at a former proceeding. The testimony or deposition of a witness deceased or unable to testify given in a former case of proceeding, judicial or administrative, involving the same parties and same subject matter, may be given in evidence against the third part against the adverse party who had the opportunity to cross-examine him. Thank you.